All right, hello everybody. My name is Mallory Newman and I'm the chair of the CLE committee for the Florida Bar Administrative Law section. I'm really excited because today I have here with me two people that I consider to be experts in Florida procurement. We have Brittany Dambley, who's the Deputy General Counsel of the Florida Department of Management Services, and Benjamin Grossman, who's a partner at the Foley & Lardner office in Tallahassee. They're going to be discussing today, government procurements and the regulatory schemes around that, and then also some of the unique legal issues that arise with these procurements. This course number is 8931, and we will be recording it. And just before we get started, I want to do a quick plug for our 2025 Administrative Law Section Pat Dorr Conference. That's going to be coming up in April 24th and 25th in Tallahassee, live in person. So I hope that a lot of you will join us for that. So we're going to get started with the presentation.
Thank you, Mallory. And another quick plug, for those of you who aren't members of the Administrative Law section, I encourage you to look at our website and consider being a member. As Mallory mentioned, my name is Brittany Dambley, and I'm the Deputy General Counsel for the Florida Department of Management Services. This CLE is being offered in my personal capacity, and the statements I make today are in no way reflective of the Florida Department of Management Services. We're going to be covering a lot of content, so I'm going to try and go quickly through the slides. Just know, as Mallory mentioned, this is being recorded, and that recording can be made available as well as the slides. It's going to include some relevant statutes and rules for consideration, but I'm not going to take the time to read through all of the relevant statutes and rules that are listed. Additionally, this procurement is going to be, the CLE is going to be covering procurement under Chapter 287, which is the purchase of goods and services. Just note that there are additional statutes that govern alternate types of purchases, like, for example, 255 governs construction, Department of Transportation has its own chapter. So today we are talking about goods and services. So we're going to start with some relevant considerations to consider in determining whether a competitive solicitation is required, the types of solicitations that can be utilized, actions taken, and some public records considerations. So for the first slide, as I mentioned, when you're determining whether a competitive solicitation is needed, some high-level things to think about if you're, for example, advising a client who's come to you and they want to know if they need to do a competitive solicitation. What are you buying? What is the anticipated cost? And does an exemption from 287 apply? Next slide. So what are you purchasing? As I mentioned, 287 governs commodities and contractual services. Those are defined in statute. DMS has delegated to agencies the authority to purchase commodities and contractual services. It also purchases some goods and services itself, which we'll talk about in a little bit. However, insurance still needs to be purchased by DMS, and if an agency needs insurance that is in excess of what's covered under the DFS Trust Fund, see Rule 60A-1.015. Additionally, if you're purchasing a motor vehicle, know that Part 2 of Chapter 287 that won't be discussed in detail today has some additional restrictions as it relates to motor vehicle purchases. And I've also listed some relevant statutes and rules to consider if you are looking at doing an information technology purchase. Next slide. So the next question is, how much is the purchase going to cost? If it is in excess of $35,000, a competitive solicitation shall be used, and you're not able to divide the purchase to circumvent the requirements. Rule 60A-1 includes some relevant considerations in looking at evaluating the cost. It also includes some additional guidelines about purchases less than $35,000 and less than $2,500. Some additional cost considerations is whether or not your agency has the budgetary authority. Section 287.0574A prohibits an agency from entering into competitive solicitation if the completion of the solicitation would require a change to the agency's approved budget unless initiation of the solicitation is specifically authorized in law, the GAA, or by the Legislative Budget Commission, and agencies cannot execute a contract to spend in excess of amounts appropriated. Lastly, for cost considerations, if you're anticipating your cost is for your contractual service or your for your contractual service is going to exceed $10 million, you need to look at doing a business case. And that's relevant because a business case needs to be included as part of a competitive solicitation. So if the entity you're advising is looking at doing a competitive solicitation, know that for contractual services, a business case would need to be done, and look to 287-0571 for information about that. And then also, if your purchase is going to be more than $10 million, and if it's IT, notice needs to be provided to the Florida Digital Service. Next slide. So then if you're exceeding the $35,000 before you start sharpening your pencils to draft a solicitation, consider whether or not there's an exemption that applies. There are certain commodities and contractual services that are explicitly referenced in statute and rule that are not subject to competitive solicitation requirements, and those are listed on the screen. Additionally, if a purchase is available off of a state term contract or an alternate contract source, we'll talk about those a little bit more, you would not need to do a competitive solicitation. Another type of purchase that does not require a competitive solicitation is referred to as a single source purchase. That's where the agency has determined that the commodity or service is available only from one vendor. If an agency has made that decision, they need to post a PUR 7776 for 15 days on the Vendor Information Portal, or VIP. That's the department's website where solicitations are posted. And after those 15 days, if the agency, after receiving any information from vendors who've indicated that they could potentially provide that commodity or contractual service, or potentially no response, the agency decides that it wants to move forward with this single source purchase, it posts a PUR 7778, providing notice of an intended decision to move forward with a single source purchase. And notice, it was important to note that this PUR 7778, this posting and this decision is a protestable decision, and a single source purchase cannot be renewed. So that's something to keep in mind when your agency is considering whether or not it wants to enter into a competitive solicitation or use a single source purchase. And also note section 838.22 sets forth some parameters around improper use of single source purchases that are considered to be a second degree felony. Additionally, emergency purchases are another type of purchase that don't require competitive solicitation. And here you need a written agency head determination that there's an immediate danger to the public health, safety, or welfare, or other substantial loss. This determination needs to be provided to the Department of Management Services as well as the CFO of DFS. This purchase also cannot be renewed. Some additional exempt purchases include services from independent Florida nonprofit colleges or universities, commodities or services offered by pride or respect, or if the state or federal law prescribes a contractor or a rate of payment. And one thing to note as well, if you're going to be purchasing something above $35,000 and you're not going to be issuing a competitive solicitation, 287.057(21) requires that you have a written attestation of no conflict for anyone taking part in the development or selection of the criteria or participating in the evaluation process or award process. So that's something that needs to be in your file, even if you're not doing a competitive solicitation. Next slide. And so I mentioned state term contracts and alternate contract source. Here, these are exempt purchases because a competitive solicitation has already been done. For state term contracts, the competitive solicitation is done by the Florida Department of Management Services, and those contracts are available on DMS's website. For these state term contracts, agencies shall and eligible users may utilize state term contracts that are procured by DMS. So this is a good place to start. If you want to look at not having to do a competitive solicitation, go to the DMS website. The statutes and rules listed on the slide also speak to requests for quotes. It contemplates, these can be oral, electronic, or written requests for pricing or services. And the agency needs to document the name of the vendor, price, the commodity being provided, and the determination is based on best value. Rule 60A-1.043 was recently updated, and it does include some additional information about requests for quotes, specifically for non-IT commodity purchases, that if agencies shall use at least 2 quotes from enterprise-wide agreements with multiple vendors unless the cost is less than 2. And if you receive fewer than 2 quotes, you need to document why you're selecting a vendor with less than 2 quotes. A use of a request for quote does not constitute a decision or an intended decision that is subject to protest. Ben's going to talk a little bit more about decisions and intended decisions, but note that requests for quotes off of state term contracts are not subject to protest. That's set forth in statute. However, be mindful of the statutes and rules that are listed and the parameters that they set about requests for quotes to minimize potential arguments about failure to file the process. Also, alternate contract sources are another type of exemption. These are commonly referred to as ACSs. Here, the competitive solicitation is done by the federal government, another state entity, or a different, it says political subdivision. Sorry, the word was right on my tongue. Here, DMS has authorized the use of an alternate contract source where the secretary has determined the contract to be cost-effective and the best value to the state. There are 2 different types of ACS contracts, and like I mentioned, Rule 60A-1 was recently updated, and one of those changes was to help differentiate between the 2, which are enterprise-wide ACSs and then agency ACSs. Enterprise ACSs is where the Department of Management Services has authorized statewide use of a contract for other agencies to use, and so further approval is not needed. But requests for quotes are contemplated. Typically, if you look on the DMS website for the contract, there will be information about the requests for quotes associated with that particular ACS contract, as well as I mentioned, Rule 60A-1.043. For agency alternate contract sources, here, an agency has likely found a contract that was previously competitively solicited and requests approval from DMS by submitting a PUR 7102. And once authorized, that is a purchase that only that particular agency can utilize. So like I mentioned, the enterprise ACSs, all agencies can use without further approval. If it's an agency, what we call a one-off purchase, a 7102 is required. Next slide. Now, I have mentioned exemptions from competitive solicitation requirements, but I would be remiss if I didn't at least bring up 2 cases to demonstrate that it's not a guarantee that use of an exemption means that you won't still have a challenge to your agency decision. Ben's going to talk a little bit more about standing and protests to agency decisions related to competitive solicitations, but these are some relevant cases I wanted to point out. The first is the Acela case, where a county had utilized another competitively solicited contract, and the court held that they had improperly expanded the scope and terms of the underlying contract, and held that the resulting, what they colloquially call piggybacking contract, needed to have the same terms and conditions as the underlying agreement that was previously competitively solicited. The other case is the Keystone case, where ACA had issued a final order dismissing a protest and a petition that had challenged a contract award where a competitive solicitation had not been done, and ACA had deemed that it did not need to do a competitive solicitation because they were purchasing off of one of these statutorily exempt types of purchases, and a competitive solicitation was not needed. Now, the DCA didn't weigh in on whether that was or was not a proper use of the exemption. They did, however, hold that the prospective bidder had standing to challenge whether the exemption to the procurement statute was properly utilized and remanded. Next slide. So now you realize that you're buying a commodity or service and it's in excess of $35,000. So there are 3 different types of competitive solicitations that can be utilized. An ITB, which is an invitation to bid, an RFP, which is a request for proposal, or an ITN, which is an invitation to negotiate. And that order is significant because that is the order in which your agency, if you're advising an agency, needs to consider doing a solicitation. You start with an ITB, and if you're unable to do an ITB, then you go to an RFP and you need to document why an ITB is not practicable. And then if an ITB and an RFP aren't practicable, here, the agency head actually needs to make that written determination about why those other 2 types of solicitations are not appropriate. So 287.057 sets forth the ITB, RFP, and ITNs. For an ITB, the type of response you're going to get is referred to as a bid. And here, price is the significant consideration. An ITB is utilized when an agency can specifically define the scope of work and establish the specifications. If an agency is contemplating renewing the contract, it needs to include that in its ITB, as well as evaluate both initial and renewal pricing. And the lowest responsive and responsible bidder wins. I'll talk a little bit more about responsive and responsible in a second. For an RFP, you're also still able to define specifically the commodity or service that you are needing to utilize, but here, price as well as other criteria is going to be utilized in evaluating which vendor is going to be awarded. Legally, you must at a minimum evaluate price as well as a vendor's prior experience. And like with ITBs, you need to, if you're going to be renewing the contract potentially, evaluate the renewal price as well and include in your solicitation that a renewal is contemplated. And here, the most advantageous to the state is going to win, and the RFP should set forth the criteria utilized in determining most advantageous to the state. And lastly, for an ITN, this is where the agency is using it to determine a way to achieve a certain objective or solve a particular problem and reach a specific goal. You must include questions being explored, facts being sought, goals or problems. And there are two phases to an ITN, the evaluation phase and the negotiation phase. And so the ITN should set forth how you're going to be evaluating your vendors, and you must at a minimum evaluate prior relevant experience as well as any other criteria that's going to be used to assist with the selection of which vendors are going to be moving forward into the negotiation phase. And once the vendors have been evaluated, the agency is going to establish a competitive range based on the scores that have been ascertained from the solicitation, and vendors within that competitive range can be negotiated with. And so a best practice would be to include a reservation of rights for the agency setting forth both for the evaluation phase as well as the negotiation phase, what the agency contemplates it's going to do in each of those stages. Here, best value is going to be the basis for award. Best value is defined in 287.012(4), but the solicitation itself can also demonstrate additional criteria about what is considered to be best value. But ultimately, the solicitation and file should document the determination of best value based on what is in the solicitation, as well as the statement explaining the basis for the selection of the vendor, including deliverables and price, and how these provide the best value to the state. For each of these solicitations, one thing to be mindful of for the purchasing entity is the selection criteria and how the agency sets forth it's going to make its award in the solicitation. Ben's going to talk a little bit more about protests, but these criteria are going to be fodder for a potential disgruntled vendor to point out when a vendor that is going to be considered for award either isn't responsive or responsible. Next slide. Now, for an RFP and an ITN, since award isn't based on price alone, there are going to be individuals who are going to be evaluating the vendor replies. And there are some specific requirements in statute that speak to who needs to be on your evaluation team if you are contracting for something in excess of $195,000, as well as who needs to be on your negotiation team. So as a best practice, the procurement file should contain details about the team members, as well as the appointment by the agency head, so that your client has information if and when there's a challenge to demonstrate that you have complied with these statutory requirements. At a minimum, for an evaluation team where you're purchasing something in excess of $195,000, the agency head shall appoint at least 3 people to independently evaluate the proposals who collectively have experience and knowledge in the program areas and service requirements for the commodities and services sought. And for a negotiation team, in addition to that type of experience, members should also have experience and knowledge in negotiating contracts in contract procurement. I bolded collectively for both of those because each individual evaluator or negotiator does not need to have all of those criteria to be appointed by the agency head. And for an ITN, if you are negotiating on something that is going to be $1 million or more in any fiscal year, legally you need to have at least one certified contract negotiator on your negotiation team. And if it's going to be 10 million or more in any fiscal year, at least one of those 3 that are legally required must be a PMI certified project management professional. Next slide. So like I mentioned in 2 slides ago, responsive and responsible vendors are going to be potentially being able to be awarded, and then depending on which type of solicitation you'll use, it'll either be lowest price, best value, and so the statute sets forth a responsive vendor is one who submits a response that conforms in all material respects to the solicitation. So, like I mentioned before, be mindful of what you're putting in your solicitation, because that can later be subject to challenge if you want to award to a vendor and another vendor argues that the individual did not meet the requirements in the solicitation. Also, be mindful that there are some statutes listed on this slide. As you can see, there are multiples that would prohibit a vendor from responding to a solicitation if they are on one of these lists that would make them subject to disqualification, or if they've engaged in certain activities. So when working with your clients on structuring your solicitation, be mindful of trying to document a way to demonstrate that the vendors who are responding are not on these lists. Like, for example, the convicted vendor list, the suspended vendor list, and so on. And lastly, for this slide, another consideration is if you have a deferred payment, payment of interest, lease of equipment, or deferred payment purchase, DFS involvement is also needed, and see the relevant statutes listed. So for the next slide. So for an ITN, an RFP, or an ITB, all competitive solicitations must be posted electronically on the Vendor Information Portal, or VIP, and must be made simultaneously available to all vendors and posted for a minimum of 10 days unless a shorter period is needed, then a written determination is required. You are not required to conduct a written conference and answer or any sort of conference, but you may. And then another thing to be mindful of in your award section of your solicitation, there are several preferences that are listed in the statutes on this slide. Not all of them are applicable. Like, for example, there, sorry, got past my notes here. There's one that specifically speaks to purchases of food commodities. And so that obviously would only be applicable if you are doing a food purchase. That is in 287.0823. Next slide. So this slide and the next slide cover what must be included in the solicitation document, whether it's an ITB, an RFP, or an ITN. These are contained in 287.0571 and Rule 60A-1.002.7 and 8. You must have a solicitation timeline, including the time and date for receipt of the solicitation responses, a public opening and location and contact information, the PUR 1000, which are instructions, as well as any other special instructions that your agency wants to provide, the scope of work, providing details about the commodities or services, as well as, like I mentioned, evaluation criteria in all contractual terms. 60A-1 recently updated the PUR 1000. So your PUR 1000 needs to be included with all competitive solicitations. And then the PUR also references the PUR 7801. The PUR 1000 can be supplemented or superseded by an agency, but one thing to note is that for the special conditions, if they supersede the limitation of liability, then the special conditions must address that topic. And then one other thing to be mindful of, the PUR 7801 includes several certifications to be made by the vendors. This rule was promulgated before the finalization of Section 287.1346. So if you are procuring commodities, then there are some additional certifications, contemplated, or that you should consider adding to your PUR 7801, and that is contemplated in that form that you can add as legal terms and requirements are supplemented to statutes. Next slide. So lastly, some additional requirements for competitive solicitation documents. You must notify vendors of their inability to submit a solicitation response and contract with a public entity if placed on the convicted vendor list, the discriminatory vendor list, the forced labor vendor list, or the antitrust violator vendor list. You must notify the vendor of Section 287.05701, which prohibits considering social, political, or ideological interests. You must also notify vendors that between the solicitation release and 72 hours after award, they cannot contact an executive or legislative branch member concerning the solicitation except for the procurement officer in writing. This is known as the cone of silence, and violation of this has been used as a basis for finding a vendor non-responsive in the past. You must also include the failure to file protest language set forth in 120.573A. If you are purchasing a commodity, you need to obtain a written certification from senior management related to forced labor. I would note that this statute requires that certification at the time of submitting a response to a solicitation, as well as before the company enters into or renews a contract. Additionally, I didn't list it on this slide, but there is another labor adjacent requirement for a written affidavit that is set forth in 787.06(13). That is not required as part of your competitive solicitation, but is required to be obtained as part of your contract execution, renewal, or extension. So that's something to consider whether you want to make that part of your solicitation, since you would need your vendor to be able to execute that affidavit before executing your contract. Lastly, if you are granting access to personal identifying information, your vendor needs to complete the PUR 1355. Next slide. So you've posted your solicitation. Now what? The solicitation itself and any addenda that amend the solicitation can be protested. So be mindful of that as you're issuing addenda, as well as when you're drafting your solicitation specifications. If you have not received a protest, either to your initial solicitation specifications or any addenda, and you're ready to complete your solicitation, you can award to vendors as contemplated in the solicitation. You can reject an offer or all offers. A reject all is subject to a heightened standard of review that Ben will discuss a little bit more. You can also cancel the solicitation and resolicit or not resolicit. And then if you do receive responses, but you receive less than 2 responsive solicitations, you can negotiate on best terms and conditions, but you need to document the reasons why you decided to not resolicit and why moving forward with negotiating is in the best interest of the state. And that is required to be reported to DMS on a quarterly basis by submitting the PUR 7200. Next slide. And so these last 2 slides are some public records considerations. Responses to competitive solicitations are exempt from public records until the agency provides notice of a decision or intended decision, or until 30 days after the opening of the bid, proposal, or final reply in an ITN, whichever is earlier. One thing to note though, in the last slide I mentioned you can reject all and not resolicit, but if you do decide to reject all and concurrently provide notice that you're going to reissue this solicitation, then that actually extends the timeline for which those responses to the solicitation can be exempt from a public records exemption. I'm sorry, exempt from a public records request. Next slide. And then for an ITN, some additional considerations. The negotiation team, if they meet in a strategy session, or if they meet with vendors to negotiate, have any sort of presentations with the vendors, or have the vendors answering questions, those meetings are exempt from public meeting requirements. However, they must be recorded and cannot be held off record, or if that is not complied with, you risk placing the entirety of your solicitation being subject to challenge and getting thrown out. So some considerations for the meetings between either the members or the vendors. The recordings and any records presented are exempt from public records request. until the notice of decision or until 30 days after the opening of the final reply. And the same as mentioned on the previous slide, if you reject all responses and concurrently provide notice of intent to reissue, that does extend the timeline. And just another thing to be mindful of as it relates to public records is if you're working with a state agency, especially is file management. Ben is going to be discussing the timelines associated with bid protests, but given that it is such an expedited timeline, one thing that you may want to consider is working with your procurement officer and your procurement team to make sure that they are organizing their files on the front end during the solicitation so that if and when you get a public records request or a discovery request, you're able to respond in a timely manner. And now I will turn it over to Ben.
Thank you, Brittany. My name is Ben Grossman. I'm a partner in the Tallahassee office of Foley & Lardner. I'm in our government solutions practice. And the focus of my day-to-day practice is state and local government procurement and bid protests. So to follow up on where Brittany has been talking about sort of the purchasing aspect of a procurement, I'll talk on the back end with respect to bid protests and challenging procurements in Florida. And we'll cover both the procedure that's applicable to them and then some of the issues that you frequently see arise in a bid protest. So we'll start by just discussing at the highest level, what is a bid protest? A bid protest is a challenge to an agency's decision or intended decision regarding the solicitation or award of a contract. Section 120.57.3 allows a protest to be filed with respect to, quote, a decision or intended decision concerning a solicitation, contract award, or exceptional purchase. So that then begs the question, what is a decision or intended decision? A decision or intended decision means a number of things. It includes the contents of a solicitation, including the addenda. As Brittany mentioned, those are things that can be protested. As we move through this presentation, that's what you may hear me refer to as a specifications or specs protest. The decision that a specified procurement can be made only from a single source. As Brittany discussed earlier, that is protestable because there is a required posting the agency must make, and you can challenge that determination when they make that posting. You can protest the rejection of a response or of all responses to a solicitation, or you can protest the intention to award a contract as indicated by the posted tabulation or other written notice. Generally for an ITB, that would be a tabulation. For either an RFP or an ITN, it's likely styled as a notice of intent to award. This definition is set forth in the rules. I have a citation to the rule there. The other thing that's important to consider is what is not on this list as a decision or intended decision. Specific to invitations to negotiate or ITNs, agencies frequently post what's referred to as a short list or an invitation to negotiate. That is not identified by the rule as a decision or intended decision. The reasons agencies originally started protesting them was by giving that point of entry early in the process. They were attempting to give rise to waiver for issues from the evaluation phase that did not get challenged when that notice of intent to negotiate was posted. There were DOA cases going both ways on whether that kind of a decision could actually give rise to waiver. That was resolved by the first DCA in 2016 in the AT&T Corporation v. Department of Management Services case, 201 Southern 3rd 852. The court noted that a notice of intent to negotiate is not one of the listed protestable decisions, and on that basis held that a bidder could not have waived the opportunity to challenge the winning bidder's responsiveness by failing to protest the notice of intent to negotiate. The court concluded by saying that that kind of challenge, the agency must make a point of entry available at the time it awards, regardless of what points of entry it had offered earlier. So notices of intent to negotiate have, from a protest perspective, become less important since then. I will note there is still one context, however, where you should be aware of notices of intent to negotiate and think through whether it could give rise to waiver, because this is still an unresolved issue. If the notice of intent to negotiate rejects the reply that your client submitted, that may still give rise to waiver given the language in the rule saying that the rejection of a response is a protestable decision. I think there is a reasonable possibility that you could see a court hold that kind of decision, if it's included in a notice of intent to negotiate, needs to be protested at that time. Turning to the next slide, the procedures for bid protests are largely set forth in section 120.57 sub 3. And I will give the disclaimer that this is the general procedure applicable to bid protests. There are exceptions, and you need to understand whether those exceptions apply. Generally, the procurement will note whether it is subject to some procedures other than those typically applicable, but there are a number of contexts with their own procedures, and those procedures can expedite the timeline even further. Some of the examples I will give you, we'll get here in a minute, but ordinarily there's a notice of intent to protest due 72 hours after the posting and a formal protest due 10 days later. There are a number of kinds of purchases in Florida where the notice of intent to protest does not exist. You are required to file a formal protest 72 hours after the posting. Some of those are purchases by the Florida Lottery, the Department of Management Services purchases regarding the state group insurance program. You need to make sure you understand, if you have a client considering a protest of a procurement, whether one of those exceptions applies to you, because if it does and you don't realize it, you will almost certainly miss the deadline for filing your protest, and that can give rise to waiver, as the statute notes. Turning to the next slide, we'll start with where the protest process starts, with what's called a notice of intent to protest. Pursuant to 120.57.3, this is generally required to be filed within 72 hours of the posting of the decision or intended decision, and that 72-hour count does not include Saturdays, Sundays, and state holidays. So effectively, it is 72 business hours to file that decision. Note that this is phrased in terms of hours. It does not speak to days. If an agency posts a notice of intent to protest at 4 p.m. on a Monday, your notice of, or if an agency posts their award at 4 p.m. on a Monday, your notice of intent to protest is due at 4 p.m. on the Thursday. If you file it after 4, you risk being dismissed for being untimely. The admin code does set forth requirements for a notice of intent to protest. It's required to be filed with the office that issued the solicitation. It's required to identify the solicitation by number and title, and it's required to state that the person intends to protest the decision. In practice, what that generally looks like is a roughly one-page letter that says, this firm represents this client with respect to this procurement. Notice is hereby given that we intend to protest your decision. Please forward all correspondence regarding this protest to this firm. In terms of where you file that, Rule 28.110.003 says that it is to be filed with the agency clerk unless otherwise designated in the solicitation. This is another place where you need to pay attention to what the solicitation says. Most agencies leave it with the default file with the agency clerk. There are some that do not. ACA, for example, generally requires their notice of intent to be filed with the procurement officer. To be safe in that situation, my personal practice is generally to send a copy to both and CC one another just to make sure there's no argument we have not filed it properly. But you do need to be aware in terms of what the solicitation says as to where your notice of intent to protest should be filed. The next step in the process, once you filed your notice of intent to protest, your formal written protest is due 10 days after the notice of intent was filed. Obviously, unless that day falls on a weekend holiday, et cetera, in which case it runs over to the next day that is not. Your protest is required to state with particularity the facts and law upon which the protest is based, and it must contain the information generally required of administrative petitions that is set forth in section 120.54 5B4 and Rule 28.106.201. As a checklist of what needs to be in your protest, Rule 28.110.004 contains a sample format. It can be helpful to go through that sample format to make sure that all of the information in that template is in your protest, because it is information that is required to be there. The other important thing to note is that your protest must be accompanied by a bond, a protest bond. For procurements under Chapter 287, the amount of that required bond is typically 1% of the total estimated contract value. For a specifications protest, you will generally obtain that amount from the agency. For an awards protest, it is 1% of the contract value of your client's bid. That can at times be difficult to determine depending on how the pricing of a contract is set forth. So it's generally a good practice in every case, when you file your notice of intent to protest, ask the agency to provide you with the estimated contract value. The statute requires them to do so within 72 hours. And you need to work timely on obtaining that bond. That is a significant gating item there. It takes time to get a protest bond issued, particularly for very large procurements where 1% of the total of the estimated contract value can be a very substantial number. And the form for that bond is set forth in Rule 28.110.005. In terms of one other note, while I mentioned that can be a very substantial number in terms of the bond amount, it is important to understand what that bond covers. Don't let your client be scared away by the possibility of filing a multi-million, or in the biggest procurements the state runs, potentially hundreds of millions of dollar bond. The vast majority of that bond amount is not actually at risk. What an agency can recover from that bond is, generally speaking, the agency's hearing costs, not including attorney's fees, if the agency procures there. As a general matter, you're normally looking at $10,000 or less of costs unless you have a monstrous protest hearing, because a lot of what that bond can cover is things like transcript costs and the costs of having an ALJ assigned to the case. Turning to the next page, we'll cover at a high level what the three different kinds of bid protests are. As I referenced earlier, there's a specifications protest that challenges the terms, conditions, or specifications of a procurement or addendum. There's an award protest that challenges the agency's decision to award a contract. And there can be a protest or rejection of all bids where an agency has decided to cancel a procurement and you challenge that. We'll get into a little more detail with respect to this later, but as Brittany noted earlier, on a rejection of all bids, there is a heightened legal standard for those protests. The agency has a lot of discretion in canceling procurements, and those are extremely difficult protests to win. In addition to those that are noted on this screen, you can also protest sole source decisions. Those are rare enough that they're not going to be one of the things that we're going to focus on today, but it is worth noting that they are protestable decisions. And there can also be what I will call sort of quasi-protests for procurements that are made through exemptions and non-competitive routes. There are paths out there to challenge those. So Brittany mentioned one earlier in terms of the Keystone peer review case. Another example of that has been dealt with by the first DCA is Asphalt Paving Systems v. Anderson, Columbia. That's 264 Southern 3rd 1110 from 2019. Just at a high level, the facts that were at issue there are an agency had amended one of it. In this case, the agency was the Department of Transportation, had amended one of its existing contracts to add additional work there and was attempting to rely on a DOT-specific competitive procurement exemption for sort of add-on work. There was a challenger who wanted to challenge that decision and alleged that the work that was being bid, that was being procured by FDOT was not within the scope of the exemption from competitive bidding. That they filed a petition raising whether the agency was complying with the statutory exemption, and the first DCA held that they were entitled to a hearing under 12057 sub 1 to challenge that decision. So that is not necessarily technically a bid protest in that it's not proceeding under 12057.3, but just know that there are potentially routes out there to challenge that kind of procurement as well. Turning to the next slide, when you file a bid protest in Florida, it gives rise to an automatic stay of the agency's procurement actions. This is again set forth in 12057.3, which requires that the agency shall stop the solicitation or contract award process until the subject of the protest is resolved by final agency action. There is a way for an agency to override this automatic stay effectively in emergency circumstances. It requires the agency head to, in writing, set forth particular facts and circumstances that require the solicitation to proceed without delay, and it requires that that be necessary to avoid an immediate and serious danger to the public health, safety, or welfare. You do not see that exception invoked frequently. It is very rare in Florida to see automatic stays overridden, but in the event you have a case where an agency overrides the automatic stay, that decision is generally immediately appealable to the District Court of Appeal under 12068(1)B as a preliminary agency action where review at the time of the final order would not provide an adequate remedy. If that happens, generally what would occur is you would file a petition alleging why you thought that the stay override was improper, and generally you'll see the DCA issue an order to show cause to the agency to explain why it was appropriate. There have not been a ton of examples of that, but it has happened a few times. Turning to the next slide, we'll cover what has frequently and historically been referred to as standing and bid protests. I put standing in quotes here because I know there are a few recent decisions from the first DCA that call into question whether standing is the appropriate word for referring to that kind of inquiry in administrative proceedings, but I will use it kind of as shorthand here, given that it's what it has historically been referred to in bid protests. The most core requirement here is the one in section 12057(3). A person entitled to file a bid protest is someone who is, quote, adversely affected by the agency decision or intended decision. And on the next couple slides, we will get into what that means, but bear in mind that to be able to protest, you have to be adversely affected by the agency's decision. In addition, the two-prong Agrico test that generally applies in administrative proceedings is applicable in bid protests. With respect to protesters themselves, you have not seen this come up terribly frequently, although there is case law from 2020 that applied the second prong of the Agrico test to a bid protest. That is the Best Care Assurance, the ACA case from the first DCA, 302 Southern 3rd 1012. Essentially, that is a very unique case, but what happened there was that in that round of the state's Medicaid managed care procurements, ACA settled some of the protests by awarding additional contracts. One of the original bidders then filed a protest to the agency's settlement contract award, arguing that the agency lacked the authority to award the contract and settlement. That got dismissed. It made its way up to the first DCA, and the first DCA held that the protester there did not satisfy the second prong of Agrico because what was going on there was the winning bidder was trying to limit its competition by challenging awards to others. And the DCA said that that type of economic competitive interest was not within the zone of interest protected by the Medicaid bidding statutes applicable to ACA. So be aware that that's out there. I'll also talk generally about intervention by the winning bidder typically. If your client wins a procurement and someone protests that, you will want to intervene. The agency generally will expect you to intervene. And given all the work that goes into winning a procurement, you'll want to make sure that you intervene early on to make sure that the agency does not change its mind and to try to preserve that win that your client worked so hard for. Typically, when you represent a winning bidder, a protest is almost by definition going to name your client as the person who won that procurement. So they will generally be specifically named, and their substantial interests are certainly at issue. So you can typically, as the winning bidder, intervene under 28-106-205 sub 3, which lets you intervene by filing a notice and appearance instead of a motion to intervene. If you represent other bidders other than the winning bidder, you will typically need to intervene via the typical petition or motion for intervention process. And while it is somewhat less typical, it is not unusual for other bidders to intervene as well. Next slide, please. So thinking through what it means to be adversely affected, this is the question of who can file a bid protest. At the highest level, ordinarily, a non-bidder cannot challenge an agency award. There are a few very, very narrowly construed exceptions to that. I'm aware of one DCA case that actually found the exceptional circumstances of a non-bidder being allowed to challenge. So do not count on your client being that exceptional circumstance. Ordinarily, non-bidders do not have standing to challenge an agency award. If you're seeking an award of the contract, it is well settled that you must allege that your client would have been in a position to receive the contract award, but for the errors that you're challenging. Second-ranked vendors almost certainly possess the standing. If your client is ranked lower than second, there is some question as to whether they meet that. Typically, for them to have an interest that would support a protest, they need to be challenging every single bidder laying between them and being awarded the contract. And at the bottom, there is the, to date, still outstanding question of what standing looks like to seek a rejection of all bids or cancellation of a contract. Occasionally, you see bidders who would not be in line for award file protests alleging that they should not have to demonstrate that they would have been awarded a contract but for the errors, because the procurement was so flawed that no one can be awarded a contract, and that they would bid on the rebid, and that is a sufficient interest. There are DOA cases going both ways on this. I would say the bulk of the more recent DOA decisions have agreed with that argument and have said that bidders can seek or reject all on the basis of fundamental flaws, but there certainly are cases going both ways. The DCA has not decided this issue. It was presented in the AHF MCO v. ACA case in 2020. That's 308 Southern 3rd 1136. But the footnotes in that case note that the agency, or note that the court did not reach that question because they didn't view it as necessary to. Just as background, the AHF case concerned ACA's Medicaid ITN and a bidder who, after learning that they would not be invited to negotiations, began violating the code of silence. They sent a letter to the governor. They held protests outside ACA's office. ACA ultimately dismissed their protest after a DOA hearing for lack of standing on the basis that they had no interest in either the contract award or a rebid, because they would be disqualified even in any rebid because of those egregious code of silence violations. The first DCA approved of that reasoning and affirmed, but it declined to reach the question of whether an ordinary bidder would have standing to seek a reject all, even if they weren't in line for contract award, because they didn't view it as necessary in that case, since the vendor would have been disqualified from the rebid as well. Next slide. There are some other limitations on who can receive relief. Generally speaking, to protest, you have to have a responsive bid. There's an intercontinental properties case, the citation's on the screen, that a bidder must show not only that the agency made an error and that the winning bidder was deficient, but also that its own bid did not have the same deficiency. As a practice tip, that can be very beneficial when you are defending an agency award. One of the strong ways to do that is to go on offense and allege that the protester themselves had a non-responsive bid and thus lacked standing to protest. Next slide, please. So your protest has been filed. You had the settlement conference guaranteed by 12057. Your case didn't settle. The agency's referred your protest to DOA. What happens now? One of the most important things to understand, particularly for administrative practitioners who might be more familiar with other kinds of 12057 proceedings, a bid protest is not your typical 12057 proceeding. The statute refers to it as being a de novo proceeding, but it is not de novo in the same sense that a CON case or a challenge to MMTC licensure might be. This is not one where you're going in to prove up your license and have the ALJ formulate agency action for you. It is one where the ALJ is reviewing the actions that the agency already intends to take. You see the citation there from State Contracting and Engineering Corporation. A bid protest is interagency review. The ALJ is not making the decision for the agency. And in fact, the case law says the ALJ cannot make award decisions for the agency. It is there just to review the propriety of what the agency has already done. Next slide. It's important to understand that once you are at DOA, this is an extremely expedited timeline that applies to bid protest proceedings. By statute, the hearing must commence within 30 days after the date the formal protest was received by DOA. That is very quick. The recommended order has to be issued within 30 days after the conclusion of the hearing or the ALJ's receipt of the hearing transcript. You've got an abbreviated time for the parties to submit exceptions to the recommended order, and the agency has to enter its final order within 30 days of receipt of the recommended order. While these timelines can be waived, doing so requires the stipulation of all parties. You should assume that in a bid protest case, this is the timeline that you're going to have to deal with. Once the case is at DOA, the ALJ will issue an order of pre-hearing instructions. It governs what happens while you're at DOA. There is a form order of pre-hearing instructions for bid protests that most ALJs use. One of the most important things that it does is it grants an extremely expedited discovery schedule. If you're used to typical civil practice or typical DOA practice, you're used to 30 or more days to respond to discovery requests. If you're a DOA in a bid protest, you should expect that your responses to discovery and your production of written documents are due 5 calendar days after the requests were served on you. This can be quite a burden. It's something that you need to plan for, because getting hit with 20 interrogatories and 15 requests for production on a Friday that you then have responses due the following Wednesday is not fun, but it's something that you have to deal with when you're at DOA in a bid protest. The other things that the order of pre-hearing instructions will do, it will require the agency to notify the other bidders that the protest proceeding is pending and that their substantial interest may be affected. And it will give instructions for the preparation of a pre-hearing stipulation. Generally, it says that coordinating the meeting to make those stipulations and preparing it is the responsibility of the agency, but it requires a lot of work of the protester, the intervener, and the agency to get a pre-hearing stipulation that is of any use to anyone on paper. And ALJs do not tend to be happy if you file disorganized or useless pre-hearing stipulations. So be aware that requirement is out there. It's something that you should be prepared to work on. The burden of proof in a bid protest is, generally speaking, on the protester. And there are different standards of review and proof depending on the type of protest. For most protests, the question is whether the agency's proposed action is contrary to the agency's governing statutes, the agency's rules or policies, or the solicitation specifications. And the standard of proof is whether the proposed action was clearly erroneous, contrary to competition, arbitrary, or capricious. While statute uses the word standard of proof, that is effectively a standard of review. You will frequently in bid protest proceedings hear them referred to interchangeably. But with a rejection of all bids, there is that heightened standard that we've referred to a few times. If you're challenging a rejection of all bids, it will only be overturned if the agency's action was illegal, arbitrary, dishonest, or fraudulent. Bid protest decisions generally contain a fairly formed discussion of what these standards of review mean. If you want to reach out to me offline, I'm happy to point you to examples of them. But at a very high level, clearly erroneous means that the decision conflicts with the plain and ordinary intent of the law, or that the factual determination lacks any factual predicate, or that there was unequivocally a mistake in the agency's logic that led to their ultimate conclusion. Contrary to competition generally means that the action doesn't align with the purposes of competitive procurements, meaning that it creates either the opportunity for or appearance of favoritism. It erodes public confidence that the bids are being awarded equitably and economically. It causes the procurement process to be unfair, or generally speaking, that the procurement is or appears to be unethical, dishonest, illegal, or fraudulent. Arbitrary, it has your fairly typical meaning in administrative proceedings, not supported by logic or reason, failing to give good faith consideration to all relevant factors. And capricious generally means that the action was taken without thought or reason or was irrational. So next slide. You've gone through all of the proceedings at DOA, you filed your exceptions, the agency has entered a final order. Now what happens? When the agency enters that final order, the automatic stay that has been in place terminates. That final order is appealable pursuant to 12068 to the DCA. If you are representing a bid protester and are appealing a bid protest denial, you need to seek a stay pending review from the agency and the District Court of Appeal as quickly as you can. It is important to recognize that automatic stay has terminated. The agency can move forward. They can sign the contract that you were challenging. Your notice of appeal is not a stay, but either the agency or the court can grant you one. But if you let the agency move forward, sign that contract, and let someone begin performing it, you could lose your access to meaningful relief and find yourself limited just to ancillary relief such as bid prep costs. I have a citation to the Hubbard construction case there that's an example of that. The DCA says that if the contract had not already been awarded, they remand for the contract to be awarded to the protester. If it had been, they're remanding for ancillary relief. And finally, I have on this slide some frequently encountered protest issues. Generally speaking, this is where it's important from a protest perspective to understand the substantive procurement law that Brittany was speaking about earlier. What the arguments will be generally depend on what kind of procurement you're in. If you're in an ITB, your argument is going to be that either the agency did not award to the lower cost bidder or that the winning bidder was non-responsive or non-responsible. If you're in an RFP or an ITN, there's a little more flexibility in terms of what you can argue, but you're generally going to be arguing either those same responsiveness or responsibility issues, or that the agency did not follow what its procurement said that it was going to do, or that in some way the agency's procurement departed from the law. One important thing to consider here, this is why specifications protests are important. If you think that what the bid specifications say are vague, they're unclear, they're illegal, they're unconstitutional, you need to protest that when the solicitation or addendum containing those specifications are issued. If you don't, they can be waived and it can keep you from raising it in an awards protest. You do not want to be representing a protester in an awards protest just for everyone's answer to be, you've known about this since the beginning, you should have raised it sooner, stop trying to get a second bite at the apple. If you're trying to raise that kind of waived issue, that is exactly what you're going to hear. One last thing to bear in mind in terms of both responsiveness and the agency following its own laws and procedures, materiality matters. Not every error requires an award to be overturned. Agencies are not required to run perfect processes. Things are only material if they give one bidder a substantial competitive advantage over the other bidders, if they restrict or stifle competition, or if they deprive the agency of its assurances that the contract will be performed in good faith. That tends to be one of the big fights in bid protests. It's largely beyond the scope of this discussion today, but be aware materiality does matter. And I recognize that we have largely run to the end of the hour, but that is the end of my presentation.
So thank you to everyone that joined today. Again, the course number was 8931, and this actually qualifies for a board certification credit for the state and federal government and administrative practice certification. Thank you so much to Brittany Dambley, Deputy General Counsel of Department of Management Services, and actually our chair-elect of the Florida Bar Administrative Law Section, and Benjamin Grossman, partner at Foley & Lardner. Again, we will be distributing this recording, so look out for that. And if you have any questions, please feel free to direct them to them. Thank you and have a good rest of your day.
Thank you, everyone.